This is Harney's Offshore Litigation Podcast. My name is Ian Mann, and I am delighted to be joined by my colleague here in Hong Kong, Andrew Johnstone. Andrew, thank you for coming.
Thank you for having me, Ian.
What exciting topic are you about to spring upon me today?
Well, I thought we might talk about the decision in CEFC Shanghai, which I'm sure you've read.
I have read. Controversial decision?
It is certainly landmark in its own way, but as to whether it's controversial, I would suggest not. It seems to me to be rather consistent with established principles of common law recognition.
And part of the modus operandi of that wonderful Hong Kong judge, Mr. Justice Jonathan Harris, who is really trying to use the power of common law recognition, which is probably done better by the Hong Kong courts than anywhere else in the world because of the unique paucity of legislation, to ensure that it is practical and has pragmatic effect with our neighbour in the mainland.
I mean, absolutely. So it is landmark in the sense that it is the first recognition of a mainland office holder using the common law powers in Hong Kong. So, I mean, it's landmark to that extent.
What's the test for common law recognition of a foreign insolvency proceeding has become actually very similar to the answer trial model law on cross-border insolvency, and there was another case also, Supreme Tycoon, which the same judge sets it all out. I mean, it's got to be a collective insolvency proceeding in a place that sort of makes sense, by which I mean either a place of incorporation or centre of main interest for the purpose of the answer model law, no such thing in common law. And it's that collective insolvency proceeding has to then use the principle of pari passu distribution. And actually that was all pretty uncontentious in this particular
In this case, absolutely. Yeah. I mean, it was the bits of the judgment deals with that. It's extremely short. And of course, this is something that Hong Kong's been doing, Jonathan Harris has been doing for a very long time in Hong Kong. We've had this in BVI, Cayman, Bermuda for ages, so much so that we've got this sort of standard form recognition order.
This is a PRC company, administrators, I think they're technically called, the EBL. Why do they come knocking on the Hong Kong court's door for recognition? What's the purpose?
They essentially wanted to stop in its tracks a garnishee order nisi that had been made, and that had of course engaged the contentious decision of Galbraith, which I think you have some views on.
Well, very interesting, because I mean, this case of Galbraith and Grimshaw is interestingly very similar to the present CEFC case. If you told those law lords in 1910 that their case would be relied upon in a Hong Kong court vis-a-vis mainland Chinese recognition, I'm sure they would be, well, extremely flattered, first of all. But I mean, similar facts, because in the case in Hong Kong, it's the creditor of the PRC company obtains judgment in default in Hong Kong, then order nisi in Hong Kong, and then in November 2019, the PRC company is wound up. And it's at that point where the mainland administrator is thinking, oh goodness, I must ensure that in Hong Kong, that particular clever creditor doesn't then make that garnishee nisi final and essentially improves its position over the general class of creditor. And that was exactly what was happening in 1911 in relation to a garnishee nisi in England following a judgment in England, and then a Scottish insolvency, which is called under Scotch law a sequestration. But in that particular case, the law lords ruled the opposite as to what Mr. Justice Jonathan Harris has ruled, and they say, no, this case is actually, it's not possible to allow the Scottish sequestration to be recognised and take effect to mean that we cannot make the order of nisi final because they're too late. And in any event, Lord Lawburn goes on to say, if we could help, it would be on the basis of the relation back period, that general rule that the bankruptcy or insolvency takes place at the time of the presentation of the petition, not when it's heard, and that in itself is fairly arbitrary. And relation back is not something that we can recognise under the then Bankruptcy Act 1883.
Absolutely.
So it becomes this really technical argument about whether or not the relation back period is important. Now, interesting, I actually did go to the source materials and read the interesting observations in a Privy Council case called Al-Sabah and Grupo Torras, which I'm sure everyone will be familiar with. And they quote the late Professor Ian Fletcher, who says Galbraith and Grimshaw, those law lords in 1910, were being a bit disingenuous, because on the one hand they don't grant the relief, but later on Lord Dunedin says, now so far as the general principle is concerned, it's quite consistent with the comity of nations that it should be a rule of international law that if court finds there is already pending a process of universal distribution of a bankrupt estate, it should not allow steps to be taken in its territory which would interfere with that process of universal distribution. I mean, it almost sounds like Lord Hoffman.
They went on and allowed it. Yeah,
absolutely. I mean, neatly done. But I suppose if you're a law lord, you can do that. So I think he's probably fair in saying it was a disingenuous decision to that extent. But in their defence, they are dealing with early 19th century.
Sure. It's not really sort of comparable to the new order of modified universalism that we all see now.
Is it as simple as that? I mean, what is Mr. Justice Jonathan Harris? How does he get away with disagreeing with the House of Lords case?
Well, I mean, both on the sort of basis that things move on, but also there's that New South Wales Supreme Court decision in Ubase, which is extremely authoritative, and I think I would have thought we would all agree that the decision is actually clearly right.
Clearly right and pragmatic. And of course, in the Australian case, the learned judge there says, well, granting an order absolute, garnishee absolute, is always a matter of discretion anyway.
Sure.
And the law has never said I couldn't exercise.
Absolutely, but where it's presented before the appointment.
And so this decision of CEFC allows the mainland liquidation to take place, and that creditor in Hong Kong doesn't have a special fast-track right to the assets. That liquidator would then prove. He still gets to prove in the mainland liquidation, right?
Sure.
Okay. So, I mean, probably what people would expect.
Absolutely. I mean, and very much to be welcomed. And particularly given the amount of cross-border transactions between the mainland and Hong Kong, it's great for all of us, I'd have thought. Which leads on to the additional question then of whether that will be extended to the other jurisdictions, which deal a lot with Hong Kong and the mainland, namely BVI and Cayman.
Oh, I thought we were going to keep this simple. You had to throw a spanner in the works. So what would happen? Should we start with the BVI?
The BVI position is a bit complex. We might need to turn it into take 20 rather than take 10 to get to the bottom of that.
Our producer is shaking her head.
And our listeners too, I think. The position of the BVI is that the cross-border recognition provisions in Part 18 of the Insolvency Act have never been brought into force. There is a sort of ad hoc power in Part 19 to grant orders at the request of a foreign liquidator.
And these are just orders in aid. They don't formally recognise.
So please, can you get the books and records turned over? Can you stop this action? So on and so forth.
And bizarrely, that's the position the House of Lords was in Galbraith and Grimshaw.
Sure.
That 1883 Act was just a sort of,
but it's not,
relief act.
It's not the generalised recognition that we come to see, for example, in CEFC Shanghai. The problem with Part 19 is it only applies to 9 jurisdictions. Only representatives appointed in 9 jurisdictions, which include such useful places as Hong Kong and the US, Finland, perhaps less commonly used, but only from those jurisdictions, and it doesn't include the PRC. So a PRC appointee cannot go to the BVI court and use the powers under Part 19.
Even though the PRC, according to the CEFC case, has a collective insolvency process under the EBL that could be deployed and should be recognised under common law principles.
So then the sort of the difficult question behind it all is, does there subsist in the BVI a common law recognition similar to the CEFC Shanghai and all of the cases we know love on that? And there are 2 conflicting first instance decisions of the same judge on that point in BVI. Justice Bannister first of all found in one of the Madoff cases that there was no subsisting common law power. It had been kind of done away with as a result of the Insolvency Act. Then was invited to correct himself in a later 2013 case called Re C, when he did say, well, he was slightly wrong.
What a courageous thing to say.
Absolutely. But he was only wrong to the extent that there was a common law power for those jurisdictions which had been carved out in Part 19, so those same 9 countries.
And in fact, that second case, after the Owen Picard case, that second case was a Hong Kong bankruptcy trustee, wasn't it? That was for Bannister's assistance.
Absolutely right. So they were a designated person.
So what you're saying is that the common law power of recognition that Mr. Justice Jonathan Harris relied upon may not be available to us in the BVI.
The current law says no, but I would like to hope that it's up for grabs, actually. I think there's a pretty good argument that the reading Justice Bannister had of Part 19 is too restrictive, doesn't apply to recognition. So I think it's all up for grabs. If anyone wants to try and extend CEFC Shanghai, it's definitely the movement of travel.
So that sort of principle, that sort of Bennian statutory interpretation principle, that if a statute deals with something, then of course the common law doesn't apply. Sure. But you're saying actually that parts of the BVI Act that are enforced don't apply to recognition generally. They're just relief.
Absolutely. Part 18 is the recognition bit. That's not enforced.
Well, you're giving all away your best arguments for the Court of Appeal, it seems. Now, what would be the position in the Cayman Islands?
So Cayman's much more straightforward.
Really?
Foreign companies, there is a statutory provision for recognition in Part 17 of the Companies Law.
Yeah.
And for Cayman companies, there is a common law power, much like the Hong Kong common law recognition. So the Cayman position is much more straightforward.
So in this case, Part 17 of the Cayman Companies Law would apply because CEFC was a PRC company.
Correct.
You go through that route, the statutory route. Well, that'd be quite satisfying for foreign insolvency practitioners to look at that and say, well, there's something codified for me to refer to. Well, exciting times. We wait for you to lead this particular area of law in the offshore jurisdictions, Andrew.
I'm delighted to do so.